Hello everyone, my name is Todd Rosenfield, and I am pleased to present today's webinar on wills, trusts, and why estate planning matters. Thank you for joining us today. Prior to getting started, let's take a look at what we will cover. First, we'll discuss what is estate planning. Next, we'll discuss what is an estate and exactly what is included in your estate. We'll then explore common reasons or motivations for estate planning. Then we'll look at different options for estate planning and the practical differences between a will and a trust. And finally, we'll discuss 3 documents that everyone should have. Before we dive into the actual webinar content, I want to share a little bit more about me and the Socius law firm. Professionally, I've been a practicing attorney for 20 years, focusing primarily on estate planning and business law. With respect to the estate planning portion of my practice, I predominantly represent those clients who are concerned about avoiding probate, eliminating estate taxes, asset protection, and planning for incapacity. I'm also an active member of Wealth Council. This is a national collaborative of top estate and business planning attorneys who are dedicated to providing what I consider to be the best planning possible for individuals and families. I'm often asked how I came up with the name Socius. Socius is Latin for close relationship, partnership, or alliance. After graduating from law school, I began working at a law firm and eventually became a partner. Over time, however, I realized the traditional law firm setting was not exactly how I had envisioned it. I also realized the importance of developing and fostering client relationships as a priority in providing legal services. Unfortunately, many law firms, including the law firm that I was working at, did not see it this way. The priority was the billable hour as opposed to the client. So I started Socius with a goal of establishing lawyer-for-life relationships with our clients. I am also often asked why it is that I enjoy estate planning. Well, as with many of you, my family is the most important aspect of my life. And in the 20 years since I started practicing, I have seen exactly what happens to families when there has been a failure to properly plan or no planning at all. So I truly understand and appreciate the importance of planning for my clients and their families, and even pets. It is extremely gratifying to be able to give clients peace of mind knowing that in the event of death or incapacity, that a comprehensive plan is in place for their loved ones. When clients tear up and give me a hug after signing their estate planning documents, I know that I have assisted them in creating something really special. Okay, a good starting point is understanding what estate planning is. Estate planning is a process for determining and understanding what your estate consists of and utilizing certain tools to carry out your goals and objectives, both in life and death. This includes a combination of documents that contain instructions or guidelines for others to follow in the event you become incapacitated or otherwise pass away. It is really important to understand that we, at least at my firm, don't just spit these documents out. They are customized for each client based upon individual goals and objectives. Lastly, it is important to note that estate planning should not be construed as an isolated transaction. It is a continual process. Life is not static. Things change, so your estate plan will evolve as well. At Socius, we stay in regular contact with our clients and assist them with updates to their plan as necessary. In my firm, every plan we design begins and ends with a definition for a comprehensive estate plan. I find that this definition covers nearly every imaginable planning circumstance for different life and death events. If I've planned for each element of the definition during a design meeting, I know that I've assisted my clients in designing a comprehensive plan. So looking at the definition, we want to control our property while we are alive and well. We want to care for ourselves and our loved ones if we become incapacitated. What we mean by this is a situation upon which you as an individual or together a married couple is no longer able to make medical or financial decisions as a result of some medical issue or some unforeseen circumstance. Next, we want to give what we have to whom we want, the way we want, when we want. This element is largely about planning for children or other beneficiaries. And lastly, we want to save every last tax dollar, professional fee, and court costs legally possible. Before we can design a comprehensive estate plan, we need to know what your estate consists of. I find that many people are often confused about what is or is not included in their estate. But simply stated, your estate is everything. Everything you own. Your home, a vacation home, any business interests you have, bank accounts, investment accounts, individual and employer-based retirement accounts, life insurance policies, collectibles, and personal belongings. Everything. An estate is also more than just money or property. You can pass on to your children and other beneficiaries a legacy that demonstrates values you want to instill in your children, or work ethic, traditions, or anything else you found important in life. Legacy planning can really add some significant meaning to your estate plan. So, now let's discuss some common reasons for estate planning. Two of the most common reasons for estate planning include avoiding probate and minimizing or eliminating estate taxes. If you aren't familiar with probate, there are two types of probate: living or incapacity probate and death probate. I will cover both of these in more detail when we discuss specific estate planning options. And with regards to estate taxes, for many of us, given the high federal applicable exclusion amount, which is currently $5.49 million for an individual or $10.98 million for a married couple, the federal estate tax is not a concern. However, the Massachusetts estate tax is a different story. Estates of Massachusetts residents who pass away with an estate of $1 million or more are required to file a Massachusetts estate tax return and may owe a significant tax. Given the high value of real estate in Massachusetts, life insurance policies, and retirement assets, your estate can quickly add up to $1 million or more. So planning to minimize or eliminate the Massachusetts estate tax is often important to many people. While avoiding probate and planning for estate taxes are the most common, there are other very important reasons for estate planning. The first of which is maintaining control. By specifying your wishes, you can maintain control and ensure that your assets are being passed on to who you want, the way you want, and when you want. If you fail to plan or otherwise specify your wishes, Massachusetts law will dictate who will receive your assets, how they will receive your assets, and when they will receive your assets. Another very important reason for estate planning is planning for minor children. We plan to ensure that in the event of an unfortunate circumstance, your minor children will be taken care of by the people you want, as opposed to being taken into temporary custody by the Department of Children and Family Services. Incapacity is another very important reason for estate planning. If you became incapacitated for some reason, you would need to have someone lawfully able to make financial and medical decisions on your behalf. Asset protection. This is big, particularly in our very litigious environment. Your child may have a drug or gambling problem, or may not manage money well. In such a case, you may choose to protect assets as opposed to giving them outright. You may be aware that your child is in a failing marriage. In such a case, you may choose to protect assets rather than exposing them to a son or daughter-in-law in a future divorce proceeding. You may also be concerned about your children being disinherited in the event your surviving spouse remarries. In such a case, you may choose to protect assets rather than exposing them to that second spouse or that second spouse's family. Another very important reason for estate planning is to avoid conflicts. Unfortunately, I have personally seen what happens when there is no planning or poor planning. Families are torn apart at a time when families should be coming together. With a comprehensive plan, this can be completely avoided. And lastly, you may own your own business. In such a case, you would need to consider what would happen to your business in the event you became incapacitated or passed away. Who would succeed or take over your business? Now that we have an understanding of the common reasons for estate planning, let's take a look at three options you have for estate planning. They are no planning, will-based planning, and trust-based planning. As we review each, you should consider which option will satisfy your goals and objectives. What I'll tell you from the outset, however, is that no planning offers no control, will-based planning offers a little bit of control, and trust-based planning offers you the most control and flexibility in estate planning. Beginning with no planning guarantees probate. There are two types of probate to consider: living or incapacity probate and death probate. First, living or incapacity probate. Without any planning, if you became incapacitated, someone would need to file a petition in court to be appointed as your conservator to make financial decisions on your behalf. Similarly, someone would have to file a petition to be appointed as your guardian to make medically related decisions on your behalf. This is known as living probate. It is important to understand that this can be very expensive, and the court controls this entire process, despite the fact that decisions may need to be made on an immediate basis for your benefit or your loved ones. A delay can be disastrous for you and your family. It is also important to consider if you have minor children and both you and your spouse are incapacitated. Someone would need to petition the court to be appointed as guardian for your children. Without any planning, your children could be temporarily placed into the care of the Department of Children and Family Services until someone is appointed by the court. The court may also appoint an individual you would never want to be guardian for your children. And second, death probate. Without any planning, at death, your estate will have to go through what is known as death probate. Death probate is the legal process that typically follows after the passing of an individual. The idea behind the probate is that the deceased is no longer around to manage his or her property, so the judge oversees the proper transfer of title or ownership to the decedent's property. Additionally, without any planning, you lose the ability to name a personal representative to administer your estate. You also lose the ability to name a temporary or permanent guardian for your minor children. Again, as with living probate, this may result in the unfortunate circumstance where the court appoints an individual who you would never want to be guardian for your children. This may also result in the unfortunate circumstance where your children are temporarily placed into the care of the Department of Children and Family Services until someone is appointed by the court. And lastly, an individual who dies without any planning is said to have died intestate. This means that Massachusetts law, and specifically the laws of intestacy, not you, will control who will receive your assets, how they will receive your assets, and when they will receive your assets. Okay, now that we understand what happens with no planning, let's talk about will-based planning. What is a will? Well, a will is a document that allows you to express your wishes as far as the distribution of your assets. A will also allows you to name a personal representative to oversee the administration of your estate. And lastly, a will allows you to nominate a guardian for your minor children. If this is all you're looking to do, then a will-based estate plan may be appropriate for you. However, for many, a will-based plan may fall short of your specific goals and objectives. And here's why. First, wills do not avoid probate. As mentioned earlier, probate is the legal process that typically follows after the passing of an individual. In this instance, however, the judge oversees the proper transfer of title or ownership to the decedent's property in accordance with his or her last will, as opposed to the laws of intestacy when there is no planning. Now, you may be wondering, why would someone want to avoid probate? First, probate is big business. The average cost to administer or probate an estate is 3 to 5% of the estate's gross value. Another important thing to keep in mind is that many people have cottages or vacation houses in other states. As such, your estate would have to be probated in that state as well. This adds even more expense. Second, the probate court is in total control, and probate takes time. It can last as much as 2 years. There may also be a delay for loved ones to have access to money or other assets. And lastly, probate is public, and everyone will know the size of your estate, as well as the names of your beneficiaries and the amount of money they just inherited. For a family that values privacy, a will-based plan may not be appropriate. Another issue regarding a will-based plan is that a will alone is no help if you become incapacitated. This is because a will only comes to life at death. So, similar to having no plan, someone would have to file a petition with the probate court in order to make financial decisions on your behalf. Now, there is a document called a durable power of attorney that can allow someone to handle all of your financial affairs, but this alone may not provide sufficient guidelines or instructions. Additionally, powers of attorney can become stale and no longer accepted. This again would require someone to file a petition with the probate court in order to make financial decisions on your behalf. Also, with a will-based plan, you are very limited in the type of planning you can do for your minor children or grandchildren. You have no control over the distributions, and this is because a simple will-based plan typically only provides for outright distributions. For example, let's assume John and Mary are a married couple who have simple I love you wills, which direct that everything be left outright to the survivor of them, and thereafter to their two children, Jane and Michael. Jane is 12 and Michael is 10. If something unfortunate were to happen to John and Mary, the court will not just hand over money and other assets to Jane and Michael. Instead, as whenever there are minor children involved, the court will require the appointment of a conservator. The conservator will manage Jane and Michael's inheritance along with court oversight until the age of 18, at which time they would receive their inheritance outright. From my experience, most parents do not want their children receiving a large amount of money at the age of 18. Most prefer that their children receive their inheritance at a later age, after graduating from college or reaching certain milestones. But with a simple will, you have no choice. Another important consideration is the fact that the conservator gets paid from your estate. As with this case, a conservator would be in place 6 years for Jane and 8 years for Michael. This means each would get substantially less of an inheritance. Lastly, simple wills do not provide asset protection or include provisions to minimize or otherwise eliminate estate taxes. Now moving on, nearly 100% of the time that I receive a call from a new estate planning client, the individual starts the conversation saying, "I need a will." And then, after meeting and explaining the benefits and drawbacks of each planning option, there is what I term an aha moment, where they realize, as you may have, the limitations associated with a will-based plan. So now, let's take a look at trust-based planning. What is a trust? A trust is a legal document that contains a comprehensive set of instructions or guidelines. It offers you the most control and flexibility when planning to care for yourself and your loved ones while you're alive and well, at incapacity, and at death. Now you might be thinking, or may have even thought, that trusts are only for the super wealthy who have large taxable estates. But this couldn't be further from the truth. As you will see, there are many other very important benefits of trusts beyond just federal and state estate tax considerations. Having a trust allows you to completely avoid probate, which, as I mentioned previously, can result in unnecessary delays and high costs. For the individual or family that values privacy, a trust offers complete privacy. Having a trust also allows you to plan for incapacity without any court oversight. Another benefit of a trust is the amount of control you have over the distribution of assets, as opposed to a simple will, which, as I mentioned previously, typically only provides for outright distributions. A trust allows you to control who receives your assets, how they receive your assets, and when they receive your assets. Many of my clients choose to stagger distributions based upon reaching certain ages or reaching certain milestones, while others choose to limit distributions for asset protection. When we plan for children or other beneficiaries, I typically ask my clients 3 questions. What would you like your children or other beneficiaries to do with their inheritance? What are they likely to do if left to them outright? And lastly, how do you feel about that? The answer to each of these questions may guide you in determining whether a trust-based plan is right for you. More benefits of a trust. For those that are concerned about asset protection, a trust allows planning opportunities to protect assets from creditors, predators, and even self-protection. As I mentioned earlier, you may have a child who does not manage money well, or may have a gambling or drug addiction. You may also be aware that your child is in a failing marriage and want to protect your assets from being exposed to an in-law in a divorce proceeding. I actually had a client who came to me after his mother passed away. His mother was aware that her daughter was in a failing marriage, that her son-in-law was not faithful and had a gambling problem. Because she did not want to lose a substantial portion of her assets to her son-in-law in a future divorce proceeding, she drafted a will completely disinheriting her daughter. When she died, her daughter received nothing, and my client, her son, received everything, several $1,000,000. Had the mother planned properly with a trust-based plan, the daughter could have received her inheritance while protecting the assets from the son-in-law in a future divorce proceeding. And lastly, as mentioned earlier, individual Massachusetts residents who pass away with $1 million or more in assets are required to file a Massachusetts estate tax return and may even owe a significant tax. This can be completely avoided with a trust-based plan. So here are the key differences on this slide. In general, a trust-based plan is right for you if you want to have a plan in place that is designed to care for yourself and your loved ones in the event of incapacity. If you want to avoid the delay and expense of probate, both living and death. If you want to control who receives your assets, how they receive your assets, and when they receive your assets. If asset protection is a concern, whether it's for your surviving spouse, children, or other beneficiaries. And finally, a trust-based plan may be right for you if you are concerned about eliminating or minimizing estate taxes. Regardless of whether you move forward with a will-based plan or a trust-based plan, there are 3 estate planning documents that everyone over the age of 18 needs. First, a healthcare proxy. This is a document that allows you to name someone to make medical decisions for you if you are unable to do so. Second, a power of attorney. Through a power of attorney, you are able to designate someone to make business and financial decisions for you if you are unable. And third, a HIPAA release. This allows those individuals you designate to have access to your medical information. And for those of you who are the parents of college kids, we recommend these documents as well. Without these documents, if they became incapacitated for any reason, you as the parent would not lawfully be able to have access to their information or make decisions on their behalf. If you are the parent of minor children, we also recommend a Kid Safeguard Plan. This ensures that your children will be taken care of by the people you want, the way you want, and never put in a situation you wouldn't like. You can learn more about our Kid Safeguard Plan on our website, but generally speaking, it is designed to prevent the unfortunate situation where your minor children are placed into the care of the Department of Children and Family Services, as opposed to being placed with the person or persons you want caring for your children. Summarized here, you can see the general list of documents and items that are included in our will-based and trust-based plans. Although it is customary to describe an estate plan as a list of documents like this, I want to emphasize that when choosing Socius, you're not just buying paper. You're getting a highly customized plan based on your unique family situation, asset holdings, and personal goals and objectives. Now, we've condensed a lot of information in the short time period that we've been together. But in summary, remember, everyone has an estate. Whether you have $10,000 or $1 million, it's imperative that you have a plan. And remember, your estate is more than just material possessions. It really is. We also looked at many common reasons that people move forward with estate planning. We looked in depth at the differences between will and trust-based planning. You may have been told your whole life that a will is all you really need, but will it really meet your goals and objectives? Regardless, your plan should be based upon your own unique goals and objectives. The worst thing you can do is have no plan at all. Okay, so that's all we have time for today. I want to thank everyone for attending. If you have any questions at all about today's webinar, I encourage you to give me a call or shoot me an email. Here is my contact information. Again, thank you for attending and take care.